but I can call this meeting to order at 6:30. This is the September 18th, 2025 meeting of the Essex Junction Development Review Board. Any additions or amendments to the agenda, Michael?
None for me.
So I guess we should launch into your normal reading and identify those of us who are online tonight.
All right. The meeting of the Essex Junction Development Review Board has come to order. This meeting is a hybrid meeting, which means that some or all of the public body is meeting remotely, and some are meeting physically at 2 Lincoln Street in Essex Junction, where the public may attend to observe, listen, and participate contemporaneously. One member of this public body or other staff is present at 2 Lincoln Street to ensure that the public can participate if desired. Please note that while we will strive to provide means for those attending remotely to participate in the public comment period, there may be technical difficulties or reasons that otherwise prevent or interrupt remote public participation. Therefore, it is important to note that the open meeting law only ensures the public's right to participate and comment at a public meeting by attending at the designated physical location as posted in the notice and agenda. If a member of the public or of the public body has technical difficulties accessing this meeting remotely, please alert me by using the chat feature on Zoom or by emailing me at mgiguere@essexjunction.org. And in the event of a technical difficulty that cannot be resolved, we may continue this meeting if necessary to Thursday, October 16th at 6:30 p.m. Please note that all votes taken during this meeting that are not unanimous will be done by roll call vote in accordance with the law. As required by the open meeting law, let's start the meeting by taking a roll call attendance of online DRB members participating in the meeting and have those members attending remotely identify themselves to ensure they can hear and be heard throughout the meeting.
John Alden, Chair.
Kristen Gilday.
We have Luke and Dylan with us here in the room today.
Perfect. All right. Item 2 is public to be heard. This is a chance for anyone in the audience that would like to speak on something that is not on the agenda tonight. Is there anyone who wishes to speak? Seeing and hearing none, we'll keep going. Item 3 is minutes of August 21st. For approval, I'll entertain a motion to approve the minutes, please.
From the August 21 meeting.
I'll second.
All right, any discussion, comments, changes, alterations? All in favor of the minutes as written, say aye.
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 Aye. Motion carries. Thank you. Item 4A is a public hearing. This is a variance application requesting relief from the minimum lot frontage requirement of section 720 of the Land Development Code at the future site of lot 6A adjacent to 29 Taft Street in the R1 district by the Center for Technology Essex owners. I'm hoping somebody is present to present this. We have seen most of this before, so I think this is probably just a adjustment to something that we saw before.
And I'm the instructor over at the Center for Technology in Essex in the residential building program. Since we were last here, I believe back on April 17th, we had gone forward with state permitting on a proposed road connecting Taft Street to Meadow Terrace, and recently got hung up with some wetlands designation on Lot 8A. Which has sort of caused us pause, and in order to continue the sort of cadence of our curriculum within the program, we've been working with Michael and gang to figure out a way that we might be able to start the construction of a house on 6A while we're waiting for the other items to push through the A&R and hopefully get the road pushed through in the future.
So is there a bigger view of this whole development? I didn't have my previously reviewed total subdivision plan in front of me when I did this. I know it came through in a somewhat recent application that we all looked at. So I know there's a circle up there. I'm not exactly sure where all the various lots are and what the long-term implication of this is, but there's a proposal for a temporary driveway that is not in the wetland, as I understand this particular request, and then that goes away in favor of the permanent driveway after the wetland issue gets resolved. Is that the case? And I guess maybe you can hover your cursor on the location that we're talking about here.
So I think it's lot 6A is the site for the next home to be built for the CTE program. And the roadway, as presented here, is labeled Meadow Terrace. So until they can resolve the state permitting issues, the proposal in front of you tonight is asking for a variance, which says that all parcels are required to have street frontage before they can come forward with a zoning permit application.
I see.
So.
What area of the proposed future Meadow Terrace is impacted by the wetlands? Is it near lot 6A or is it somewhere else?
It's centered on lot 8A, I would say closer to the west side of the lot. The buffer zone for the classification of wetland puts it a good portion of the way through the road, or the proposed road.
Ideally you will reorganize Meadow Terrace, but it won't ultimately affect this parcel. Is that what you're hoping? And we just don't know that yet because we don't have a final plan yet.
Correct.
Do you see a case where the subdivision has to get reworked so that the proposed temporary driveway becomes the permanent driveway, or is that not expected?
It's really unknown at the moment. I mean, obviously, we would love to have the connecting road go through because it means many more years of curriculum for the students. But if a great portion of 8A is unusable in the end, we'll just have to examine as to whether that's like financially responsible on part of the district to move forward with the whole road or not.
Hey, John, I'm going to hop in just for a brief second here and ensure that we swear in all participants from the public
right.
hoping to speak tonight.
Thank you.
So anyone either for this application or the next agenda item on tonight's agenda, if you plan on presenting testimony or speaking as a member of the public, if you would raise your right hand and take the following oath. I hereby swear that the evidence I give in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury. And say I do.
I do.
Thank you.
Thank you, Michael. Michael, do you want to weigh in on this temporary proposal here? I'm not. I'm totally in favor of the concept of allowing this so that the program can move forward. I don't want to slow that down. I just need some, or I think the board needs a little assurance that I mean, we might be able to continue. Let's say you're still in this position next year. Is there you just go around the circle that's there now and keep making driveways until you can't do that anymore, or what what happens here?
Great points. And I think, staff on reviewing this echoes a lot of what you're presenting here. We'd love to see this program continue as well. So your staff report is broken into two sections. The first of which is me just checking with you all that you agree with our interpretation that we're considering this to be a temporary driveway. I included some comments about the fact that, technically speaking, it doesn't meet our geometry standards for the R1 district, but that we're treating this as kind of phase one of the roadway's completion, and that when the roadway is able to be completed, the applicant will be required to reconfigure the driveway, returning certain sections to natural or grass, and ensure that it meets LDC standards. So I have a drafted condition of approval in this variance request for you to consider as a part of that. But this variance is essentially just allowing the applicant to proceed building the next single family home on this parcel as if a roadway existed. And on the smaller zoomed in site plan that I have up on the screen right now, you can see it's rough. The wetlands buffer is roughly parallel to the road, giving you an idea of how close this is. Notwithstanding the executive order that came from Governor Scott's office yesterday, that has some adjustments to wetlands impacts that our office is still considering that might be a potential avenue in the near future.
I'm just trying to imagine the possible future pathways, which include the road doesn't go through, but we still make we still have a viable some number of lots. They just don't happen to look like the plan that we had already approved, because the wetlands are too disruptive to the previous plan. And is there any harm to doing that? And I don't know that there is or isn't. That's what I'm kind of getting at. Is if the worst case is we end up with one or more lots that are off the circle here instead of off a future through road, is there something that we're doing that is worse than doing nothing?
It's a great question, and the LDC does have some provisions that I think tends to try to limit development at the end of dead-end streets. And there's also an existing gravel cycle and footpath roughly where the proposed Meadow Terrace roadway is, and we'd want to make sure that we're maintaining that as well. So any future development proposals or reconfigurations of what this subdivision looks like in the future, if the roadway does continue to run into roadblocks, we'd need to make sure it meets LDC standards.
But so far, the proposed temporary development of this lot doesn't trigger anything. Just another lot on a circle.
Correct. Yeah, we're just proceeding with the home building with this temporary driveway.
Yep. All right. Well, I don't have any more questions. Anyone else on the board?
Yeah, so maybe a follow-up to John's question. If the permanent roadway is unable to be constructed at a future date, there's no access issues for the homes that are in progress or planned at the moment?
I believe when we had met back in April, we pushed through like a 3-lot subdivision with 6A being the only buildable lot.
Yep.
And we were going to come back and hopefully work with you folks on a plan unit development type deal so we could build out the curriculum as best we could. But this time there's no other, there's no other lot that's buildable at the moment.
Okay. You're not constructing a home that's accessible only by the temporary access road that is then going to presumably go away, and then if it's not replaced with something more permanent. So.
So the temporary access road that's like a gated emergency road at the moment,
Okay.
the gate would just shift and it will maintain that because the community garden uses the opposite end of that access road. That will stay, and this driveway would just feed off the current curb cut in the cul-de-sac to service this one lot.
Got it.
Yeah, and most of the cul-de-sacs that I know of that are in the city limits already, they have complete houses all the way around the circle. So sometimes there's a little slot left for a future exit strategy or a road extension, but you know, I don't see anything out of the ordinary on this. It'd just be nice if somebody first of all, you're way up on a hill there. I just don't even like what kind of wetland have you discovered up there is my first question, but I'll leave that to the wetland people.
So it's classified as a Class 2 wetland, shrub with the presence of certain dogwood vegetation and hydraulic soil. It's Class 2 mainly because it's 0.61 acres in size, and that is what triggers the necessary 50-foot buffer zone around that area, which encroaches on the proposed roadway and takes up a great deal of Lot 8A.
Yeah.
As it
And I
is
would
now.
be interested to see what the executive order of yesterday has, what kind of impact there is on this kind of. I'm guessing it's exactly the kind of thing that the executive order is hoping to sort of reduce the likelihood that some isolated wetland materials in the middle of a otherwise rolling hillside terminate an ongoing housing development that was started years and years and years ago and looks like it's going to continue. So anyway, we'll have to wait and see on that. We'll let the professionals do their thing and work it out. I have no further objections. Are there any other board questions?
Maybe just one question procedurally. If it turns out that the executive order does provide relief in this instance, what would happen? I mean, would you imagine just proceeding with the original proposal if the variance is granted now, this evening, but you find out 3 days from now that the EO does provide cover? Would you?
It would be our hope to push off the connection of any infrastructure until after year one of the build, in hopes that we would either not have to put in the proposed pump station to access the cul-de-sac on Taft Street and just connect to the proposed sewer system that would run and connect to Meadow Terrace.
Okay.
So we're going to hold off as long as we can on making those things, because those would prove costly if they had to be changed midway through.
Understood. Thank you.
Yeah.
All right. Anyone else on the board? Any members of the audience have any comment on this application? I see none. I don't have my copy of the proposed amendments right in front of me here. Or proposed language. Maybe you can help me with that, Luke. But Michael had some recommended language.
Condition of approval.
Yes, please.
Upon completion of the roadway connecting Taft Street to Meadow Terrace, the applicant shall reconfigure the temporary driveway serving Lot 6A to comply with the special standards of Section 618H of the Land Development Code.
All right. Anybody want to make that as a motion?
Yeah, I move that the DRB approve the variance request seeking relief from the minimum lot frontage requirement of Section 720 of the Land Development Code at the future site of Lot 6A, adjacent to 29 Taft Street in the R1 district by Center for Technology Essex owners, with conditions.
Seconded.
Any further discussion? All in favor, say aye.
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 Any opposed? Motion carries unanimously. Thank you very much, and I hope you got that project back on track.
Chris.
Thank you. All right, public hearing number 2, item 4B, appeal of administrative decision regarding the issuance of a notice of violation for cannabis cultivation operation at 8 Taft Street in the R1 district by Jason Struthers, owner. Is Jason our representative here tonight? All right. And are they coming up to the table? I don't know how much of a, we had about 60 pages of material to read for this tonight, so there's well enough documentation in front of us already. Michael, do you want to just lay out a quick overview for us, and then we'll see if there's any other presentation or discussion to have?
Yeah, we could do this in a number of ways. If you want me to read through my staff report as an overview, we could start there. Yeah, Chris.
I was hoping for a 2-minute summary, because we've all read it. I don't know if anybody else needs to have you read it to them, but just a very brief summary I think will suffice, then we'll get the show on the road here.
Yep, give me 1 second. All right, so let's see. A July 14th decision was issued by Essex Junction's administrative officer to issue a notice of violation against Struthers concerning outdoor cannabis cultivation on his property at 8 Taft Street. This is a prohibited use currently within the R1 zoning district where the property is located. Struthers claims that cannabis cultivation use is grandfathered and permitted to continue as a non-conforming use under Section 801 of the Land Development Code. The administrative officer does not believe that the cannabis cultivation qualifies as non-conforming use, and the administrative officer's reasoning is outlined in a separate memo, which is in your packet, and he's also here tonight to give verbal testimony if needed. And so notice of hearing was provided to all persons. And your packet also includes positions as to the timeline of events that led up to tonight's hearing.
Yeah, and there's a lot, so I will outline my thought process, and people are going to decide if they need more. But the real question that I have, since the state of Vermont has, at the Supreme Court level, has ruled that cannabis cultivation does not need to be allowed because the municipal body's rules can decide where it can happen and where it cannot happen within their municipality. And since we prohibit that activity in the R1 district, the state is saying we can do that. So the next question is, does it come to the point of being a grandfathered use, in which case it would have to be a use that was ongoing before the rule started that said it's no longer allowed. And my understanding is that the Land Development Code has been prohibiting agriculture uses in the R1 district long enough that the applicant's claim cannot be true. Is that correct?
The administrative officer has taken in as to why the notice of violation was justified. Yes.
So we went back into our land development codes, and I've probably been on this review board I probably was around when we looked at the 2016 version of the LDC this afternoon, and it clearly already states that you cannot have agriculture in a R1 district. It's not a permitted use. So if Mr. Struthers started his agriculture business or his practice in 2022, he would be in violation of an existing rule, and therefore he should be subject to the notice of violation, as it cannot be a grandfathered use. So that's the way I look at it. If anybody else has a different way of looking at that, I'm happy to have them come forward and explain it to me. So I will start with Mr. Struthers and his representatives, and I'll go on to the public if that's necessary. But it looks pretty cut and dry to me, so I'll need some convincing.
Convince you, and I got all the receipts for it. Just the actual issuance of this notice of violation is an act of bad faith by the city. If anything, I should have been notified that I'm grandfathered. So, to the first point, Mr. Ewan states that because cannabis is considered agriculture, that they have the ability to zone it. Well, that is just 100% false. I don't know if he's conflating New York. New York recently put into law that cannabis is considered agriculture, but in Vermont, cannabis is not considered agriculture. Act H270 gave us protections similar to farms in regards to nuisances like smell, which is why we're here. But, you know, if you do some research, you'll find out that, in fact, cannabis is not considered agriculture in Vermont. And, I mean, this is a little nitpicky, but a plant or tree nursery should be deemed an agricultural related entity, but I'm not an orchard, I'm not producing any fruits, and I'm not producing any seeds. So, then again, it's a little nitpicky, but, so, there's that. So, there's a couple other things I want to bring up. Here's the original license I received from the Cannabis Control Board. You can see that it was issued July of 2022. The documentation that was released by Mr. Ewan, in fact, states that Land Development Code changes were made in September of 2022. Now, you guys were close, but you missed it by a couple months. So, there's that. You know, should you guys deny my appeal and this goes to court, that's okay. It'll give me an opportunity to also challenge the cultivation district in and of itself. Because, well, before I get, well, I'll get to that first. The cultivation district in and of itself isn't in violation of state law. So, if you look at the Vermont statutes online, Title 24, Chapter 117, Subchapter 007. A municipality, let's get to the good stuff. The adoption of a cannabis cultivation district shall not have the effect of prohibiting cultivation of outdoor cannabis in the municipality. Well, if we look at the cannabis control, or the cannabis maps provided by the city from EssexJunction.org, you can see that the only people that can cultivate according to this map would be the Whitcombs, Global Foundries, and then a few parcels of land that are in a residential area and located to a densely populated residential area. So this cannabis control or cannabis cultivation district violates the statutes that I previously mentioned. Because it basically prohibits anybody from, I don't know, there's maybe, I've seen one parcel of land for sale that was available that you could buy and cultivate on. So, there's that. So, to qualify for a pre-existing non-conforming use, it's very simple. I've lawfully established my business before the Land Development Code changes were made. I've had continuity of use. I annually renew my license. I have not abandoned the business. It's a minimum of 6 months. You have to abandon it. And I'm not sure if I think that might be it in terms of pre-existing non-conforming uses. So, cannabis is not agriculture. My license was established, albeit only 2 months before you guys made your changes, but it's 2 months, and I qualify. Furthermore, the cultivation districts you established are violation of state law.
Anything else to say, or are you okay now? You're finished.
I can cite case law that substantiates my point. Vermont State, let's see, sorry, I should have been a little bit more organized. It's been a busy day. I've been doing a lot of cultivating. Here's some information on why cannabis is not legally defined as agriculture, if you want to read that.
Was that submitted in our packets?
No. This is from the Vermont legislator, vermont.gov. This is Vermont Statutes Online. So this is official. I can give you links and you can look it up for yourself.
Not gonna help me at the moment. There might be somebody else in the room that can help explain that to me, but that's an interesting conclusion that cannabis is not agriculture. When I read the definitions for agriculture, it sure sounds like it to me. So
Looking forward for some time to get the protections that farmers have, but we don't have that yet.
no.
And you can verify all this information with the Cannabis Control Board members, if need be. Also, this is a after Act 66 was written and basically written just to put me out of business, the legislators actually commissioned the Cannabis Control Board to complete an impact study. And this is also available online from the Cannabis Control Board, or I can give you this copy. But it gives you some really good data. They did a survey, as Mr. Ewan as obviously knows. I'm sure he filled it out. They surveyed every municipality in Vermont, and only 2% were found to have any problems. And as of right now, the city of Essex Junction is the only municipality to institute a cannabis cultivation district, and the only municipality to issue a notice of violation to anybody regarding cannabis. So if you read the report, because of this, the Cannabis Control Board basically says this isn't a good means of enforcement or communication, given that only one municipality is taking advantage of it. And so they're basically telling legislators not to use it moving forward. This also has all the information you may need on the setbacks, but again, these setbacks were instituted far after I got my initial license, so really don't pertain to me. And that, I guess, really is all I have.
All right, I'll move on to other comments. Anyone else in the audience that would like to speak? Take an orderly turn at the mic, please. And state your name and address for the record.
Hello. My name is Stephen Willie Padnos. I live at 6 Taft Street, adjacent to Mr. Struthers. In my opinion, this is essentially a frivolous appeal based on a specious argument. In fact, in his appeal, he says that when he first got his license in July of 2022, cannabis was to be regulated as agriculture, which he, let me just read the relevant portion, since he seems to think he didn't say that. Paragraph 1. Yeah. My cannabis cultivation operation was licensed by the Vermont Cannabis Control Board on July 20th, 2022 as a Tier 1 outdoor cultivation facility, license number. At that time, cannabis cultivation was classified as agriculture under the LDC and Vermont state law. This is his own claim.
That's bad information.
Okay.
I mean,
In any case, hold on, Jason, it's my turn. You can go after. Thank you. Maybe. So, another thing he pointed out when speaking is that cannabis, or he said that cannabis isn't considered agriculture under state law. That's actually not what the state law says. It said it's not considered farming under state law, and there's a difference. Farming has very specific federal law attached to it, which includes a prohibition on cannabis. And I think, but I'm not sure, that was one reason why the state explicitly separated cannabis from farming so that we wouldn't jeopardize our farm subsidies. I did read through those laws, and I don't have my notes on where they came from, but there are two statements in state law about that. One is that cannabis is not considered agriculture for a purpose which has to do with taxation and farming. It says that it is considered agriculture and not development for purposes of permitting under Act 250 and certain other things. So in the same section of, I think it's section 869, they actually claim that it is both not farming, but also it is agriculture. I'm sorry, I can't cite the actual paragraphs. In any case, in this claim, he continues, so in the appeal, he continues and basically says that effectively that the Supreme Court ruling said that it is okay for municipalities to regulate cannabis, but that it's not okay for municipalities to regulate agriculture. But that's not true. The decision provided clarification of the law, which was in effect in 2022. So, because agriculture was not allowed at that time, and because it's very obvious that cannabis growing is agriculture, which, by the way, says growing of a crop, among other things, is considered agriculture. So it doesn't matter if it's seeds or leaves or wood. There's no basis for grandfathering because this operation was never legal. So continuing in the appeal, he says that the LDC changed after the license was granted. It's true, but irrelevant. One of the points, or one thing that may not have been noticed, when looking through state statute, is that there's a requirement for cannabis licenses and renewals, and that is that all applicants must attest that they will comply with applicable municipal ordinances. So the Supreme Court clarified what is applicable, and he's willfully ignoring this promise to follow the rules. The attestation is not that the operation will comply with the rules that existed when the license was granted. It is, quote, that they will comply with applicable municipal ordinances. This one I did write down. It's section 144B. Sure. So this is section 144B of the state CCP rules, which you can easily find at the state CCP website. It's Rule 1. So he claimed that he hasn't, in the appeal, he claimed that he hasn't expanded the scope of the operation. I believe this is false. My understanding of grandfathering and what it means to expand an operation is that the actual activity may not increase, not that it just can't exceed the original amount allowed by the license. So as an example, if in October of 2022, when the LDC changed to prohibit cannabis growing in the R1 district, even if he were grandfathered, if he had, for instance, 50 plants at that time, and I don't know the number, but as an example, if he had 50 plants at that time, he would be grandfathered for 50 plants, not for the number that are allowed by the license, which is 125 plants. You can't expand the amount of the violation. This is equivalent to a house that was built before setbacks were implemented, and then building an addition on the front of the house, which increases the amount of the violation. So the license type hasn't changed. The license still says that 125 plants are allowed, but I believe, and I think Ms. Safar, if you consult with her or another attorney, should definitely clarify that. But this year, just anecdotally, I see many more plants than before, certainly many more than there were in 2022. And they're planted much closer to the property line than they had ever been. And it's just interesting to note that most of this planting was done a week after the Supreme Court decided against him in that case. So, regarding the setbacks, there's no square inch of his property where a 50-foot setback can be followed. It's 100 feet wide at the road, and it gets narrow from there. So there is literally no place to plant. But that doesn't mean that it's not possible anywhere in the city. He recognizes that the Supreme Court decision decided that municipalities can regulate cannabis, but failed to acknowledge that agriculture or farming may also be zoned by the LDC. He said that the decision doesn't retroactively invalidate pre-existing uses. In fact, the decision should have retroactively invalidated his incorrect interpretation of the law and how it should apply to him. His operations have caused a great deal of harm to our way of life. We can't enjoy our backyard due to the terrible smell. We had to put up a fence to block the view of the junk pile that is his backyard, including piles of tires, old fencing, barrels, and what looks like construction debris. There are also several structures that were put up to house the ducks, that he had to provide fertilizer for the cannabis. Those were under the assumption that he was a farm and he could build whatever he wanted. So I'm here to ask that the DRB uphold the NOV, and if you have any power to do so, please impose or direct the city to impose the maximum penalties allowed by law. This situation has been going on for far too long. It would be a travesty if the callous, belligerent, and illegal activities of our neighbor went unpunished. The other members of the neighborhood have been punished already, and we didn't do anything wrong. Thank you.
Thank you very much. Are there other members? Yes, sir. Right behind you. Yeah, yes, sir. Come on up to the mic, please. And state your name and address for the record, please.
My name is Ronald Fry, Sr. My address is 16 Taft Street, Essex Junction. I'm a resident on the street involved. I'm about 300 plus or minus feet from where the cannabis is being grown. In a simple way, all residents have rights. And in this particular case, there is the right of the person growing the marijuana. And around this person, there are at least 3 homes that abut against it. And they have rights too. During the summer, as we are now ending, marijuana stinks. And even being 300 feet away, my wife had been going outside to let the dog out, and she kept saying, we've got to bring them in because there are skunks in the yard. There weren't skunks. What was coming in with the wind was the smell of the marijuana. Recently, when we go to pick up the mail, the smell is strong. And the neighbors surrounding this project are suffering as a result of this. A couple of the neighbors felt that they couldn't let their children go out and play because of the smell wafting across onto their property. And I would argue that the value of the homes, when they go on the resale market, will be diminished substantially. I wouldn't want to try to sell a house with the smell next to my house. I'm not a lawyer, and I don't have as much information as the parties before me, but I'm familiar with the Right to Farm Act. And I'm bringing that up because at the time when Mr. Struthers was raising the ducks and raising the marijuana, he was claiming that he was a farmer and that the Department of Agriculture had given him the right to farm. Agriculture did not give up or the legislature did not change the taking away of marijuana from the agricultural law until after the marijuana had initially started being grown. So at the time, when retroactivity is being asked for, it was farming. And I'm trying to think here, if you'll give me a minute. Under the Right to Farm Act, it was written in order to protect farms that were later surrounded by residences. And the idea was to protect the right to farm. In this particular case, it was the opposite. The residences were there long before the farming, in quotes, was taking place, long before the marijuana was being grown. So it seems that at the time, again, when the initial growing of marijuana was taking place, it was agriculture, simply agriculture.
Thank you. Anyone else in the audience have something to say? There's a hand in the back. Gentleman with glasses, you come on up and state your name and address for the record, please.
My name is John Workman. I live at 12 Taft Street in Essex Junction. Jason, is the microphone close enough so you can hear me?
It is.
Okay. So if I may, through the board, I have a couple questions. Did the applicant ever do a survey of any of the neighbors in this residential neighborhood and let them know what he was intending to do? Is that a question I can ask the board?
We're not aware of that kind of survey.
Never, as far as you know, that never happened.
Yeah, my position, as I stated in the last time we were all together, was that the use was not prohibited, was not a viable use in that district, and it's been in violation since day one. So they don't need to come to us to start these operations. We're not, we didn't give a permit to do this or anything of the kind. The first thing that the DRB heard about this was that he was claiming that the state had awarded him a farming designation. And my first question was, how is that possible when that's not permitted use in that district? You can't have a farm there. So you couldn't have had somebody come in and say, oh, you're a farm, because the farm in itself is not permitted. So you're in violation day one. Continue, please.
Just on the humanity issue, I'm just wondering what the applicant was ever thinking to think that he could drop a farm use right into the middle of a residential neighborhood and bring in farming equipment, agricultural equipment, feed, stock, all that brought into the middle of a residential neighborhood with children. And myself personally, I will tell you that on a personal basis, I don't happen to smoke marijuana. I don't care for those that want to. It doesn't make any difference to me. Nothing against it. But I happen to be asthmatic, and the smell of skunk combined with the smell of manure is the thing that sets me off. And I used to be able to open my windows, and I can no longer do that. I cannot invite anybody over to our backyard to have a simple backyard barbecue like any other of you here in this room that can do that. And we can't do that because the pungent odor is so disgusting. If I took a bottle of manure and mixed it with the cannabis smell and passed it around, we'd have to go with smelling salt behind it to get everybody back up again. I don't understand where the applicant thought that he could do this, why he didn't have the humanity, the decency of going around to the neighborhood and say, this is what I'm thinking I'm going to do, because I know if he'd asked his own parents, whom I knew personally, if he was going to do that, they would have told him absolutely not. And now this has happened, and it subjected everybody, and I agree absolutely. After 40 years as a licensed real estate broker, I can tell you this: the neighbors of that property have a duty to disclose. And the duty that they must disclose is to a potential buyer of anything that could affect the property use of their property. Anybody would be remiss not to disclose what we are all subject to there. And is it going to reduce the property value? That's an appraiser's opinion, not mine. But I can tell you just from practicing real estate for those many years that it's absolutely, positively 110% going to reduce the number of people that are interested in purchasing the property. Now you can argue, does that mean it reduces my property value or not? Again, that's an appraiser's decision to make. But I can assure you it has an effect on the properties that surround this farming use, agricultural use, commercial use, people coming and going all times of the day, and driving by a nice neighborhood with nice, well-kept properties, to respect each other, the humanity of it. For the neighbor to respect a neighbor and take care of your property so everyone can enjoy that neighborhood, that residential neighborhood. And then you come on to what the hell just happened. And it's just absolutely disgusting. It's humanity. I know all the legal ins and outs, and he can play the game as long as he wants to play the game. I hope you folks hold his feet to the fire. If I wanted to live near something like that with manure and animal smells and all those things, I would have gone down and bought something by the Wickham farm. God love them. I love our farming community. I grew up here. I'm fourth generation. There were a lot of farms before Jason ever came along. And that's where he needs to be. Go get a farm, Jason. Get out of a residential neighborhood. No one begs you to do what you want. Get out. Go someplace where you can be welcome at what you're doing. Clearly, if you don't get it tonight, and you haven't got it over the last couple years, you will never get it. And that's very, very unfortunate. And you can laugh, but you're laughing at yourself, my friend. You are laughing at yourself. Thank you for your time.
Thank you, John. I'll just remind everybody that comments should be addressed to the chair and not the board and not the individuals in the room. Anybody else have anything to say on the topic tonight?
Okay. All right, from Steve. State law on farming, cannabis. Well, so on May 4th of 2023, the Vermont Agency of Agriculture, Food and Markets issued me a determination of formal farm. I am a farm. Whether these people like it or not, they are
You're
entitled to
still
their
in
opinion.
violation.
They are
You're
entitled to their. It's not in violation.
You can't have a farm in an R1 district. You cannot.
Prior to the
rules-
Supreme VSA 4413 was interpreted even by this municipality, and the memo was issued by Chris Ewan back here. I have it right here. The city is
Yeah.
powerless to enforce anything against cannabis or farming related. So now, even
that
though you guys have a
interpretation was-
Supreme Court decision, I know everybody's very excited about that. One thing Steve brought up is I planted my crop after the Supreme Court case decision. Yeah, because the Supreme Court didn't say that I needed to stop what I was doing, that I was in violation. It was remanded to Superior Court, and that's it. And that's what happened. So now the Supreme Court and the Superior Court say yes, farming and cannabis can be regulated by municipalities. That is not the dispute here. What I'm saying is that no matter what, I was farming cannabis, and you can call it farming or not farming or agriculture, whatever. I was growing cannabis in July of 2022 before you guys had any rules against it, and therefore I'm grandfathered. I have a pre-existing non-conforming use. July of 2022, my license is right here. The documentation handed out by the municipality says laws weren't changed until September of 2022. So it's quite clear. I mean, you guys can waste tens of thousands of dollars more of going to the court. It's fine. I'm happy to go back to court. It's only going to cost me filing fees. You're going to waste tens of thousands of dollars of taxpayer dollars, which is fine, because I would like an opportunity to challenge the cultivation district itself. It's in violation. So the 50-foot setback, Steve mentioned, not applicable. Supreme Court. So why were there two decisions if agriculture and cannabis are the same thing? Why was there two different dockets? There weren't. They're not the same thing. They're not legally the same thing. Otherwise, it would have been one docket, only about farming, only about ducks and cannabis, but it wasn't. The only notice of violation that was issued to me initially was about my ducks. Because you couldn't issue a notice of violation to me before then. Hello? You were powerless to issue a notice of violation against me in regards to cannabis before now. And even now, you guys aren't even recognizing the grandfathering. So let's go to court. I'm all for it.
Thank you.
Ron Fry, rights versus feelings. Well, you know, we are here because I'm required to follow laws and rules. We don't call the feelings police. So while everybody is, can give their opinion and share their feelings, they are meaningless. Yeah, there's been a lot of allegations about people being sick and not being able to use their backyards, but I have pictures of everybody using their backyards, kids playing and all sorts of other stuff, so kind of irrelevant. So again, the right to farm was brought up. There are two different subjects. You're conflating two different subjects. The ducks was farming and agriculture. Cannabis is cannabis. You guys would have issued a notice of violation against me against cannabis years ago, but you couldn't, and you didn't. Now we're here. So.
Do you have any new information for us, Jason? I have other members of the audience who are wishing to say something.
There's allegations I was bringing in equipment. I don't have equipment. You know what I mean? Like, this is all ridiculous. And furthermore, you know, since you brought it up, my parents would be proud of what I'm doing right now. So just for the record. And also for the record, I mean, no matter what, there will always be cannabis growing in my yard.
Sharon, online, I see you have your hand up, then I apologize if I haven't gotten to you sooner.
Right.
Like, I've got someone online first.
Sorry, me?
Yes, you, Sharon. Go ahead,
Okay.
please.
I also see Craig Dwyer has his hand up. So a couple of things, you know, we're talking about a license, and we're talking about grandfathering, or at least Jason is. I have a professional license. I've had a professional license for 20 years. It's not the same license. It's been different. And the reason it's different is because they expire. The license that I have expires currently at 5-year intervals. I've had other licenses that expired in 1 year or 3 years. Every time they expire, I have to get a new license, just like anybody else in any other business. And, you know, under the new license, I have to follow the rules that are there. If the rules get changed mid-license, I have to follow those rules. That's what we have to do when we have a license. But if my license lapses, I don't get to be grandfathered because I had a license 20 years ago, or I have a license now and I let it lapse for a year. I have to get a new one. And whenever I get a new license, I have to abide by what those rules are. It doesn't matter if my licensure, you know, I got it in 3 years ago and now they say, oh, you have to do these things now, or you can't do these things. We're changing your rules. I have the license. If I want to keep practicing or using that license, I have to honor what is being presented. It seems like it's kind of nonsensical to try to say you get grandfathered for something that's a license in cannabis sake of every year. That seems silly to say to me to me, it seems silly to say, I had a license 25 years ago or 3 years ago in this case. So I'm forevermore grandfathered and I'll get to do what I want the way I want it. That doesn't actually make any sense to the common person. But the other thing that Mr. Struthers has said just recently in trying to refute things is that you know, I don't know if he actually read the Supreme Court decision closely, at least, because the Supreme Court decision said that what was going on for the last many years in Vermont is interpreted as being farming was only really about water quality. A municipality cannot regulate something called water quality that the state already regulates. It's doing double duty, right? I don't have to go through and explain it all again, but that's what they're talking about. And they're not making a new rule about it. They're clarifying something that's been on the books for many years, but probably misunderstood by all the people until now. And it took this case and this person who's willing to push it this far in a residential neighborhood and just be completely combative to make it so that it is, you know, has gone to the Supreme Court, and the Supreme Court has clarified what the rules actually are. They've always been there, and that is spoken in the Supreme Court's decision. It says that there. They said they're clarifying what has already been. So, you know, again, it negates this question of supposed grandfathering. It doesn't actually make sense. None of what he's saying actually makes sense when you look at what is actually real. And that's all. Excuse me.
Thank,
Have a cold. That's all I have to say.
thank you, Sharon. I'm gonna go to Craig Dwyer. He's got his hand up online, please.
Can you hear me?
Yes, sir.
Okay. I think everyone pretty much spoke about I think I understand. I'm trying to understand, you know, where my neighbor's coming from. You know, I don't have anything against Jason Struthers personally. We got along first couple of years I lived here. I think it's really putting it into perspective that Essex Junction is the fourth most populated city in the state. out of 277 municipalities. That's according to the 2020 US Census. So it's not the right to do it. I think it's where. And I understand the perspective of wanting to grow, but it's the fourth most populated city in the state. It just happens to be where it is, and unfortunately, because it's the fourth most populated city in the state, the homes are close together and it's going to have an impact on people's quality of life. I think that's why all the neighbors are here. It has impacted my family, it being adjacent to our backyard. It does have a potent smell that's present in my yard and inside my home. And for some reason this year, there's more cannabis plants along my fence line about 2 to 3 feet away that didn't exist before. Is that the best place to grow it? I would gather probably not in the fourth most populated city along a fence line with children. We've been hosting our children's birthday parties and other children events at public parks. Do we have the kids play in the yard? Yes, it's their yard. But the impact of the smell, you could say it's feelings, but it has an impact. And all I want is really simple for my kids to just use the yard, for the house not to smell, especially during August and July when it's hot, and for the DRB just to ensure my family's quality of life. And unfortunately, it's where it's being grown, not up against the fence line. So that's all I want is my family's quality of life, and that involves upholding the judgment order from the Vermont Supreme Court. Thank you for your time and the DRB and all the work you do. And I know there's bigger things going on in the city with building, 4-story buildings and other things that are very important that you dedicate your time to. But it has an impact on neighbors. And I wish there was a way to balance it. But when it's this tight of an area, I think that's what really I'm hoping for everyone to understand and consider. Thank you.
Thank you very much. Any other new hands in the audience? Chris, I see your hand is up, and then I'll come back to people that have already spoken.
I'm Chris Ewan, the Community Development Director and also the Zoning Administrator for the city that wrote the notice of violation, that issued the notice of violation. I just wanted to be here to answer any questions, but also to go over some of my reasoning behind why why I went ahead and issued the notice of violation, and why my position on the topic has evolved over time as more decisions have come out from the courts. So my decision to issue this notice of violation was in light of the Supreme Court's opinion that cannabis cultivation operation is not exempt from all municipal regulations simply because he is a licensed outdoor cannabis cultivator. But it's also important to note that after the Supreme Court issued its final opinion and remanded the case back to the Superior Court, there was a judgment order that was issued. It is in the last, it's the last attachment in the DRB's packet. And on the last page, it says that the court grants the city's motion for summary judgment and concludes that the appellant's duck farming activities are prohibited by the LDC. So it makes it clear that that farming is prohibited and that it can be prohibited. It also chimes in on cannabis. And after explaining the reasoning behind it, the court says that it grants the neighbor's motion for summary judgment on cannabis and denies the appellant and the city's motions, and concludes that the appellant's cannabis operations are prohibited by the Land Development Code. So this issue has already been essentially discussed at the courts. And we're here at the city. I can only use my I can only read the court's decisions and interpret the land development code accordingly. So my reasoning behind issuing the NOV kind of comes down to several things. First of all, the plain language of the regulations prohibits cannabis cultivation in the zoning district, and this is because of several reasons. The first I say here is that cannabis cultivation constitutes agriculture or farming. So yes, it does say in state statute that cannabis cultivation shall not be regulated as farming under the required agricultural practices, but the courts have already clarified what that actually means, and that is to do with the regulation of water quality. So, prior to the city implementing or amending the land development code to explicitly include cannabis cultivation as a land use category, it wasn't clear, but in my opinion, it fell under the definition of agriculture at that time. Agriculture was always prohibited in the R1 district, even before Struthers began his operations. So it was never lawful and cannot qualify as a pre-existing non-conforming use. Yes, this does differ from how I interpret this at the beginning, before the courts issued any decisions, but based on what the court says, this is what I think now. The second reason is because of claim preclusion, which bars a grandfathering argument. There is a legal doctrine called res judicata that says that if it seeks to prevent the relitigation of a cause or action finally adjudicated between the parties in an earlier suit, and this preclusion applies when the previous final judgment on the merits already exists, when the case involves the same parties, which it does, and when the claim has been or could have been fully litigated in the prior proceeding. So this issue was discussed in the courts, and Struthers had never brought up grandfathering as one of the defenses. So for that reason, I believe it cannot be brought up now. Annual cannabis licensing requirements also reinforce the ongoing compliance obligations. The VCCB every year requires that the local Cannabis Control Commission confirm that the cannabis cultivation is in conformance with local regulations, including zoning. And this happens every year. So if it only needs to conform at one time and doesn't need to conform in the years to come, what's the point of going back to the local Cannabis Control Commission every year? I think if the VCCB requires the local Cannabis Control Commission to chime in every year, that seems to me to be a reason that it needs to stay in compliance. And the last case, the last issue here is there are limitations to non-conforming uses. Even if the DRB determines that the cannabis cultivation at 8 Taft Street does qualify as a legal non-conforming use, any expansion of that use remains prohibited. It's just like any other non-conforming use, just like setbacks. If you can't go further into the setback if new setback regulations prevents your existing building from being where it is. So, Section 801A of the LDC states that a non-conforming use shall not be expanded or extended to occupy more land or floor area than it occupied on the effective date of the code and shall not be expanded to displace a conforming use. So if the allegations are correct that the number of plants has increased in recent years, at least the number of the additional number of plants to me would be not permitted. So the same issue applies with the 50-foot setback. Sure, if there were already some plants within the 50-foot setback, and if the DRB determines that it is grandfathered, that amount of encroachment into that setback, we can't do anything about. But any additional encroachments into that setback, in my opinion, would not be in conformance to the land development code. So it is for those reasons that I have stated above that I think this notice of violation is valid and should be upheld.
Thank you, Chris. Everyone who's wanted to speak has had a chance.
I'd like to respond one more time, very quickly. I understand this is taking a long time, but this is my hearing, so. Okay, so Mr. Ewan's ignorance of the law doesn't justify his conclusions. So before the NOV, like I explained before, the NOV wasn't issued because you couldn't issue an NOV. So the NOV was issued when we had a conference of a committee with the Superior Court, and during that time, my lawyers were going to withdraw, and I was going to submit a motion to appear pro se. Excuse me. So there was never an opportunity to address this NOV because it was issued after the committee of conference. When we were speaking, you can go back and watch the video. Claudine Safar is there. The judge specifically asked Claudine Safar, the municipality's attorney, has a notice of violation been issued? And she said no, but it is imminent. So at that time, a notice of violation wasn't issued, and it couldn't be responded to. Or grandfathering or pre-existing non-conforming use couldn't have been brought up at that point. So now that we're going by your rules here. This is your process. So now that this issue is notice of violation has been issued, I've been granted. I'm appealed. I don't expect a fair hearing here. I don't expect you guys to grant my appeal. I expect this to go back to Superior Court where a judge will rule upon this. So, and going back to and Mr. Ewan claims that my pre-existing non-conforming use is invalid because of expansion. Okay. Here's my original license, 7/29/22. I am a Tier 1 small cultivator. I am allowed 125 plants every year. Doesn't matter if I had 70 last year, 65 before the year that. If I want to have 125 this year, I can. And I just submitted my license renewal with the CCB, which they accepted. The Cannabis Control Board will be voting on my license at the end of the month on September 24th. Then it's going to go to the city council where they're going to have to approve my license because I'm going to appeal this when you deny me this. So we're going back to Superior Court. And by the time this gets through, I'm going to be done my harvest for 2026. So I'm already game. But here's my license. Here's my renewal. Still a Tier 1. My license this year, still a Tier 1. So 125 plants, 125 plants, 120 plants. There has been no expansion. If I expand to a Tier 2, a Tier 3, a Tier 5, that'd be a different story. But I haven't. And there wasn't a local cannabis control commission when I got my license because that was the same month that the village of Essex Junction became the city of Essex Junction. So if you go back, you won't find any meeting minutes to approve my original license because there was no commission. Your rules were not in place. So you can make whatever rules you want. You and Supreme Court can make a rule that you can't grow cannabis at all in Essex, period. But I have a pre-existing non-conforming use. So it's okay, we can let a judge decide.
Thank you very much. I'm gonna close the public hearing and I am gonna go to my board. Wait, I did have one, gentleman. This will be your second time up. If you want to say one more thing, you've got 2 minutes.
Jason, when I first moved into the neighborhood,
You need to address the chair, not me.
we talked from time to time, prayed from time to time, and I thought you were a pretty regular person. The thing
right
that
to the-
set me off in this particular situation was that I heard from the neighbors that when they talked to him, he said, "I don't care about you or what you think. As a matter of fact, I don't care what anybody in the town thinks." That's characteristic of what's going on. Jason can be very intimidating. When I go by his house with my car, I get the finger. When he won the first case, he danced around me and tried to intimidate me and bait me.
I can't dance.
This is the guy you're dealing with, and the town should not be intimidated by him.
You're being very intimidating right now.
People let you speak and didn't interrupt you. It would be very nice if you would give other people the same respect. You have laughed and made comments this entire time, and respect goes a long way. So
Call me a fraud all you want.
I haven't said anything of that nature. I'm just asking for you to please be quiet unless you are at the chair and show some respect.
Thank you.
Thank you.
All right. Public hearing is closed. We've heard persuasive testimony from both sides. The most persuasive seems to be from the courts already. State Supreme Court and the Superior Court have both weighed in on this. It's not a secret what they think. It's not a secret that they gave municipalities, they have clarified that we do have the right to tell any use where it can be in our municipalities. We have districts for everything. It's regulated just like everything else. I still don't understand how we got into this situation in the first place, because there was never a point in time that Mr. Struther's activities were legal. So if I were able to do something about it, I would, and I don't know exactly what what happens when somebody ignores or breaks a rule, but I would find that there's been a problem since day one, and I would figure out how to do something about that. But that's not my job. My job is to look with the board at the rest of the things that are in front of us right now tonight, and to decide whether or not we think that the notice of violation that was issued by our zoning administrator is lawful. So would the board care to ask any further questions at this time or discuss it amongst themselves? Or are we ready to vote?
I'm ready to vote.
Yeah, ready.
Are you looking for a motion, John?
I'm looking for a motion, please.
I move that the Development Review Board uphold the administrative officer's notice of violation for the cannabis cultivation operation at 8 Taft Street in the R1 residential district.
Do I have a
Second.
second? Any further discussion? All in favor, say aye.
Aye.
Aye. Any opposed? Motion carries unanimously. Thank you. What else do we have on our agenda? Do we have anything else on our agenda? Are there other Development Review Board items for this evening?
None for me.
All right, anyone else? I thank the audience. It's great to have everybody come out. This is the biggest audience we've had in quite some time. It is our hope that we can get a grip back on our municipal zoning districts and have them enforced as they were meant to be. And it's my sincere hope that violators will be dealt with as is applicable with our rules. Thank you very much, and I will hope to see some of you next time. We don't get a lot of visitors. Look for a motion to adjourn, please.
Seconded.
All in favor, say aye.
Aye.
Aye, motion carried. Thank you all. Good night.
Recording stopped.
So you could go up to 2 hours, or actually up to 6 hours.
On one film?
On one film.
6 hours on one film?
Yeah.
How can you go 6 hours on one film?
I don't know. The tape moves really slowly, and it.
The movie thing is like the ones like this only for a half hour. The great big reels like this are only for about 45 minutes, half hour.